Welcome back. In the new criminal law bills which sparked a massive political war were passed in Rajya Sabha today. These bills include the Bharatiya Nyaya Sanhita, which will replace the Indian Penal Code, Bharatiya Sakshya Sanhita, which replaces the Indian Evidence Act, and the Criminal Procedure Act will be replaced by Bharatiya Nagrik Suraksha Sanhita. According to Union Home Minister Amit Shah, the existing laws were of colonial era and never focused on giving justice to the citizens. These new laws are based on new principles and individuals' freedom and citizen rights, honouring human rights and impartiality. The Congress party and opposition has criticised the way these bills have been passed without any presence of the opposition members. Former Home Minister Mr. P. Chidambaram has not actually dumped the colonial laws, and he has said that this is a mere renaming exercise. So are the new law bills a majority, it's a reform that we are looking at, or this is a repressive exercise? Is this really something what opposition calls a name-changing exercise, or the pith and substance of law has been changed?
अंग्रेज चले गए, पूरे देश में 4 प्रकार की न्याय प्रणाली चलती थी। आज कश्मीर से कन्याकुमारी और द्वारका से लेकर कामाख्या तक इस कानून के आने के बाद एक ही प्रकार की न्याय प्रणाली का चलेगी।
Well, joining us on the broadcast is the third-time sitting MP, member of the CWC and chairman of the Parliamentary Standing Committee, jurist and national spokesperson of the Congress, Dr. Abhishek Manu Singhvi, joining us on the broadcast. Dr. Singhvi, thank you so much for joining us on the show. Cutting straight to the topic, to the brass tacks of it, the government argues that this entire move is a reformative move and it is aimed at shedding the colonial baggage. Do you agree with that argument, sir?
Unfortunately, and I say with great respect, there cannot be a greater misrepresentation than this. This is completely wrong, and let me give you on that just a few figures first. There are about 1,059 sections in these mega acts. For 150 years, we've had IPC, and then 75 years CRPC and Evidence Act, etc., etc. Actually, in a real sense, they've made changes in the IPC, which is now called BNS.
Yeah.
To only 2.24% of the provisions. They claim they've made 34% changes, and I'll tell you why there's a hiatus between 2.24 and 34. It's because they've simply picked up 30-40 provisions of the old one and consolidated them into one chapter or into one heading. Chapter 2, Chapter 17. It's nothing but a transfer and a consolidation. So you count every comma full stop as a change, then it comes to 34. The real change is at 2.24%. That's your structural change for you. The second is the BNSS, the erstwhile CRPC. They claim 22% in the same cosmetic manner, completely cosmetic. Actual changes is 1.68%.
All right.
And last is the Evidence Act, called BS now. Claimed is 13.77%. Actually, is only one change. 0.17%. Now, therefore, it is not wrong to say khoda pahad nikla chuha, or shayad chuha bhi nahi nikla. Before I come to the 3 or 4 important facets, and we'll go along as we go along, one is a set of things which you could do. It's a missed opportunity you did not do. Nobody is saying you don't require changes. We're all welcoming changes. Laws require updating. So first is, what are those which, had you done, would have been welcome, but you did not do. You missed an opportunity. Second is the ones you did. Many of them, how retrograde and blunderous they are. And the third aspect is that really it is your fetish for name changing. I don't want to sound political, but let me tell you that you somehow love to leave your identity, your imprint, your chhap, as they say in Hindi. So you have gone on a name changing spree. In the political sphere, from 75 to 2013, you
Okay.
have 33 examples where you simply change the name of schemes. This is a very major change, example of merely a change of the name of a statute.
Well, sir, I take that point, but give me substantial reasons. You argued that at length, but I'd like to know more. That why this is a cosmetic exercise. The government argues that, look, for example, the offence of sedition, a commitment that they gave to the Supreme Court of India that we do away with it. They have come through on it. And sedition as an offence as it earlier existed on the statute book does not exist. And in fact, these are progressive changes that have been made. One of the examples that I'm quoting out of the many key changes that have been made, sir.
I mean, you have to start consulting Alice in Wonderland dictionary. I call it retrograde and the government calls it progressive. One of us has to be wrong. Now you judge for yourself. There are 4 examples of retrograde I have chosen. There are many, many, many more. But of the 4, let me take your example first, sedition.
Sure.
I mean, I'm amazed that somebody in the government is calling it progressive. I said, not entirely in jest, that certainly the government can't be accused of sedition itself, but it can be accused of betrayal. The government makes a statement, first of all, in the courts on 11th of May 22, the court gives a stay of the sedition offence. They reiterate it on 30th of October 2022 and record the statement of no less than the Attorney General that we are seriously reconsidering. Seriously. The result of that so-called serious reconsideration is that on 24th May 23, which is 1 year later, the Law Commission reincarnates sedition. And immediately on the next day, if you read the newspapers, the government distances itself from its Law Commission, saying, "Hum to sarkar hai, ye to Law Commission hai, Vidhi Ayog hai." As if they are fooling people who believe that the Law Commission is functioning in a silo or a ivory tower itself. Now, what is reincarnated today is worse than the previous provision. There is no difference in substance. What about your assurance that you'll do away with it altogether? And the old one had a punishment, Anusha, of life plus 3 years. This one has life plus 7 years. And this is your definition of much better provision, progressive or more tailored. Last point.
Sure.
You are sitting in Gujarat, you say anything the government doesn't like, the Assam police comes and arrests you for sedition. We have done those cases. I'm actually a lawyer in many of those cases. You are sitting as a journalist in Uttar Pradesh. How many of your colleagues have been arrested for sedition? Now, today, by simply changing cosmetically something or the other, there is no change. It is worse. Now, let me give you 2 or 3 other quick examples of retrograde. You have created a new offence of sexual intercourse by deceitful means. This is a new provision, clause 69. The law standing committee report itself very strangely puts it under the head, appreciated provisions leading to love jihad. So this kind of provision is a satisfaction of your preconceived agenda about love jihad. Why? Because you have given a humongously disproportionate penalty of 10 years for this. 10 years.
Okay.
You already have an offence that you are deemed to commit rape if you have sex on false pretenses.
Yes.
Now you have made it into a separate offence for love jihad. Clearly you know how it is used in actual on the ground. Innocents are harassed. Today it carries a 10-year.
Sure. Sir, there's this one issue that I want to talk to you about, and there has been much chatter about it. You would know that better as a litigating lawyer, that how does this reorganization or renumbering of various provisions, consolidation of various provisions of the Indian Penal Code actually affect the existing jurisprudence, and a rich one which has been set by the High Court and the Supreme Court in this country?
You have again brought me back to the most vital practical concern. And you could not be more right. This is the consequence when you act without knowledge. These unintended consequences are the most dangerous.
Sure.
I'm not saying anybody's intention, including this government's, cannot be to increase our arrears of 5 crores to 7 crores. No man on earth would want that. I'm not accusing the government of that. But as they say, the path to hell is paved with good intentions. Howsoever good your intention, if your unintended consequence of your actions is 5 to 7 crores, the best example is this: you have tinkered with whatever 500 odd provisions. actual change of a substantive nature or of a real nature is 2.24% or 1.68 or 1, but nominally, facially, the changes are 34% to BNS IPC, 22% to BNSS CRPC, and 13% to BS Evidence Act. Now, that many changes means that you are a judge. You got 100 Supreme Court judgments on section XYZ.
Okay.
You know it inside out. When an accused or prosecution comes, you know how to slot him. You are right, you are wrong, as per judgment so and so. Now, today, the first thing the accused will get up and say, my lords, there is new law now. This is changed. A comma is changed. Now you decide it all over again. That Supreme Court judgment which you had doesn't bind you. Now, the funny part is that the judge will ultimately reiterate the Supreme Court judgment. But that will take time. The certainty of established jurisprudence goes.
Okay.
The certainty of having a law which covers it goes.
But sir, to conclude, and this is my last question to you, coming back to the original question that I asked you, shedding the colonial baggage, it's a loaded term, and in many ways, to break it down into different portions is very difficult. Have we actually shed the colonial baggage? And if we have, in what way and in what form?
Answer to the second question is tragically no. Absolutely no. I've just given you the reasons and the examples. How can you shed a colonial baggage, so-called, with these percentages of changes? But the first question is more important. Look, Anusha, these are not matters to be decided by ideology or preconceived, premeditated object. You must change your law if it is bad. You must not change it because it was made by Aurangzeb, who is considered a cruel ruler. You must not change it. Suppose he made a very good law. Should you change it only because it's his name? Therefore, the British made good laws also. But equally, the British made bad laws. You are changing them not because they are British made. You are changing them because they are bad laws. Now, that exercise, if you are done with that mindset, you ended up changing and doing a lot of good.
Okay.
Who is saying that the IPC is perfect? But the examples I have given now, take for example what you did not do. Police reforms. One of the most important things you could have done. Now, this is what you could have done, did not do. The other example was what you did was wrong.
Okay.
Police reforms makes a simple Chinese is unfashionable, Indian wall between prosecution and investigation. You know, your average investigator, IO as they call them, gets up in the morning, the poor fellow goes in the field, collects some evidence, obviously gets attached to it because he's the one who's collected it, comes back to the office and sits with somebody in his own department, his superior, etc., to decide whether it's prosecutable evidence. His own evidence collected is prosecutable or not. Does odd chores for his superiors, wastes his time, and attends 2-3 hours of court also.
Okay.
Imagine this man's plight. A, he's overworked. B, there is a lack of objectivity, impartiality and transparency. If I collect the evidence and I also decide prosecution. Now, you have been told by 40 years that separate these two. Prakash Singh's judgment in Supreme Court, several law commission reports. You could have done that by this amendment. Now, did you do that? Why? You talk of colonialism, you talking of British. You do not actually wanting to reform.
Okay.
That's the problem. Take, for example, making it more reform and less punitive. Why didn't you increase? So therefore, it's clear that I want changes. But what changes is the question. Why don't you increase the list of compoundable offences? Compoundable offences are those which you can settle.
Yeah.
Now, there are innumerable petty offences which can be always added to the compoundable list, like impersonating a public servant.
Sure.
These are matters where if you want to settle, you can't settle. And you will clog your courts and clog your jails. Third, punishment alignment. These are changes you should have done. Today, there are a number of provisions where an offence is more serious, the punishment is less.
Yeah.
And the next provision is, and the next offence is less serious, but the punishment is more.
Okay.
Take, for example, bribery during elections. It is only 1 year. Inciting a riot is only 6 months. Align the punishment proportional to the issue. You have not done any of this.
Dr. Singhvi, thank you so much for joining us on the broadcast. It's always a pleasure to speak with you, and especially on this sweeping reform that has been brought by the government, which you substantively criticized on this broadcast today. Taking the conversation forward is with another learned senior advocate, Mr. Aman Lekhi, who's also the former ASG. Mr. Lekhi, good evening, sir. Thank you so much for joining us on the broadcast. Straight to the point, these are historic reforms, whether one agrees with them or disagrees with them. And they are the reality of the day. They have been passed by both houses of the parliament. Your initial thoughts on the key changes?
Well, I would consider it hasty and not one which has been preceded by due consideration. The pre-legislative scrutiny, which is obligatory, is lacking. And the enactments, as has been legislated, have terminological problems apart from duplication. As an exercise of recodification and virtually actually substitutes the existing system with a different one. The occasion to bring it about, the justification for the change, and the terms in which the change had to be brought about had to be properly considered and meaningfully presented. There is neither proper consideration nor meaningful presentation. And I find these enactments lacking altogether in certain basic requirements of good statutes. So as far as the exercise is concerned, I personally feel that this exercise is wanting on all counts and is unbecoming of the advanced legal machinery which is available in India, and which we have in operation, and in fact slights it with the method in which it has been brought about.
Sir, it's rather a rhetorical term, but it has been used very often in the context of these three laws that we have shed off the colonial baggage. What is colonial baggage? What have we actually shed off? And in your understanding, what have we really achieved with these three new laws?
Our jurisprudence is not in any way burdened by colonial baggage. It is distinctively Indian, and we've evolved it considering the Indian circumstances and applied it to the requirements of a polity. Mainly because it draws upon statutes which are in some way prior to our gaining independence, doesn't necessarily mean that the statutes are incapable of application or by reason of sheer age justify this epithet of it being a colonial baggage.
Okay.
You please understand, as far as colonial baggage is concerned, this involves the concept of cultural hegemony. And implicit in it is an element of subordination to a superior power. When you talk about colonial baggage, the person will have in mind is the Kipling's stories, the white man's burden.
Yes.
The suggestion of the Home Minister that the government is ridding the country of this colonial baggage is utterly misconceived, because that was not present. Our laws may have drawn upon the past, but nevertheless have been applied to our requirements.
Okay.
And the first principle of recodification is identifying the areas which require attention, and the legislative policy of the government itself contemplates the government specifying what are the areas of concern, why are they to be addressed, what are the reasons behind this particular exercise, and what is the manner in which it's going to be done. Now, apart from very emotive expressions, which in many ways are legally misleading, there is no exercise whatsoever on this account. So we have this particular expression, but for the justification of this particular expression, we got absolutely no evidence. And I denounce this description, and I do not in any way subscribe to this method of in some way belittling the existing legal system, because the system is distinctively Indian.
All right. Point taken, sir. Sir, you've been one of the few voices when sedition was put in abeyance by the Supreme Court. You pointed out to the various nuances of that particular order. You also criticized the manner in which it was put in abeyance. But the government argues, look, we have made substantial changes. We have done away with the offence of sedition in the earlier form. There are important changes that have been brought in. One of the key criticism of these three laws has been that this is just a name-changing exercise, just renumbering which has been done. Do you agree with that? Or the pith and substance has been changed in a great manner? This is actually reformative in the manner like the government argues it to be.
Well, I find it paradoxical. The government which invoked sedition, defended sedition, applied sedition, is today in parliament saying that in doing away with sedition, it is getting rid of colonial baggage. So what is it? I mean, are they slighting themselves or insulting themselves? Whatever done in the past, I really don't understand that. Now, if sedition was that bad, why is it that it was invoked till the Supreme Court stayed it? Now, as far as my personal opinion is concerned, I still hold that sedition is a necessary offence. Of course, it has to be applied sensibly. And I'm against what the Supreme Court did, staying that. But the point is, what is the stand of the government? The government has been applying it. And because the government is applying it, really doesn't behove the Home Minister today to say that, see, we have now redefined sedition because they were quite comfortable using sedition the way it was originally enacted. So this really, it is playing to the galleries. It makes absolutely no legal sense. One. Two. As far as the content of sedition is concerned, the word sedition is absent. But the gist of sedition is there. But as I was saying in the beginning, the terminology is deficient. Because what is very pertinent in criminal law is precision. Because it is the application of the law where the efficacy of it is going to be tested and the impact will be felt. Now, if the way of expression is in some way loose and the interpretations can be multiple, then the occasions or applications would be numerous, with there being no check on how and when it is to be applied.
Okay.
Now, if that is going to be the impact of criminal law, then as far as liberty is concerned, it will be in perpetual peril. So, as far as the question is concerned, what the government has done is, it has retained the essence, not referred to the word, but yet in the expression has given to itself more copious powers.
All right.
So, this is duplicitous, I would say, insofar as the speech is concerned,
Yeah.
because we are assured by saying that, see, this is a democratic India. So, we don't have the mindset of the colonial empire, which was inimical to our interest. And at the same time, while paying lip service to this particular principle, we have in the statute book that which enables us to do precisely that, if not more than what the colonial rulers could do.
Okay.
So we have to be forthright. But I behold the government that we believe in sedition. We disagree with what the Supreme Court said. We think it is necessary that sedition should be over there.
Yeah.
And we will apply it according to the circumstances sedition requires. Why is the government not forthright about it?
Okay.
It makes no sense to me. The government was in the forefront invoking sedition. Why is it defensive about sedition today?
Okay. Okay.
So they're obviously playing to the gallery and they're scoring boundary points where these viral videos about how progressive these laws are serving political purpose.
So taking this conversation forward, I was speaking to Dr. Singhvi also as to how this entire exercise is going to have an impact on the existing jurisprudence that exists in this country. Dr. Singhvi argues that in some way it could create confusion or it could impact the existing jurisprudence coming in from the Supreme Court or the High Courts across the country. What is your view on this matter, sir?
Well, I don't see I don't see jurisprudence being affected. The jurisprudence has got certain settled principles. The settled principles are the bedrock of our system. They are the bedrock of our system because they encapsulate the values with which we live. Now, those values are immutable and eternal. Whatever the laws may be, the laws must conform to the values, and the values are settled and in position. So the jurisprudence is evolved. I don't agree with what Dr. Singhvi is saying. It's not as if it's going to be chaos.
Okay.
That's why is it? There has to be a settled system of applying law. That system is in place. What we consider as inalienable remains so. What we consider as something which is basic is recognized as such. And whatever values we think are dear cannot be forsaken. Okay. Now, if that is so, even the new law which will come, will be in line with the values of the system. It will be in line with 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 the system. It will the new law will be seen in the context of those fixed principles. So because if the principles are fixed, notwithstanding the changes which are made, insofar as continuity which is there will persist.
Okay.
And continuity is absolutely basic for any legal system, because you can't possibly play around with the system as such. We can tinker with it
All right.
in some way to adjust it to the changed circumstances, but at the same time we cannot abandon or debunk it.
All right. Sir, thank you so much. It has been an absolute pleasure to have this conversation with you. The laws are here and all eyes on how they're going to impact and overhaul the Indian legal system. Mr. Aman Lekhi and Dr. Abhishek Manu Singhvi joining us on Brass Tacks tonight.